dissolving a business entity requires more than just closing your doors. Whether you have a corporation or an LLC, proper dissolution involves formal documentation, state filings, and specific legal procedures. Getting these steps wrong can lead to ongoing tax liabilities and potential legal complications. When dissolving a business, both corporations and LLCs must follow formal procedures that typically begin with a resolution to dissolve. This resolution documents the official decision to end the business and requires approval from shareholders or members. For corporations, dissolution starts with a shareholder vote. You'll need at least 50% of shares voting in favor of dissolution. If your corporation has no shareholders, the board of directors must pass the resolution with a majority vote. This formal resolution should clearly state that the board has the authority to dissolve the company and that there are no shareholders. Once the resolution is approved, corporations must file a certificate of dissolution with the Secretary of State's office. This certificate must be signed by the majority of directors, and the corporation isn't legally dissolved until this document is properly filed. An officer of the company needs to create and sign the document. Corporations must also file IRS Form 966 within 30 days of adopting the resolution to dissolve. This form must be accompanied by a certified copy of the director's resolution. If any amendments occur to the resolution, an additional Form 966 must be filed within 30 days of each change. For LLCs, the dissolution process is similar, but has some key differences. The process typically begins with member approval through a resolution to dissolve. Your LLC's operating agreement usually specifies the required percentage of votes needed, commonly a majority or supermajority. While the IRS doesn't specifically require LLCs to file Form 966 unless they're taxed as corporations, a resolution to dissolve is still essential for legal and record-keeping purposes. Most states don't require you to file this resolution, but you should keep it in your records. After approving the resolution, LLCs must file state-specific dissolution documents. Many states require both a certificate of dissolution and a certificate of cancellation. The certificate of dissolution is often required if not all members unanimously voted to dissolve, while the certificate of cancellation formally ends the LLC's rights and responsibilities in the state. Both corporations and LLCs must take additional steps beyond filing paperwork. You must promptly notify all creditors and claimants about the dissolution. For corporations, you also need to notify any shareholders who didn't vote in favor of dissolution. All business debts and liabilities must be settled before distributing remaining assets to shareholders or members. You'll need to file final tax returns and cancel all business licenses, permits, and registrations to avoid ongoing fees. Some business owners attempt to dissolve without filing formal paperwork by simply ceasing operations and allowing their registered agent to resign. While this might eventually remove your company from good standing, it's not recommended. This approach can lead to accumulated fees and interest, and your business name may remain unavailable for future use. The risks of improper dissolution are significant. You may face continued tax liability even if your business is inactive. Members could lose legal protection, becoming personally liable for claims against the business. And without formal cancellation, your business name rights may be compromised. Properly dissolving a business entity is crucial for limiting future liability and ensuring a clean break from business obligations. Whether you have a corporation or an LLC, following the correct procedures protects you from unexpected complications and provides peace of mind that your business affairs are truly concluded.